Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Thompson v. United States. In this case, the court considered this issue. Does the prohibition in 18 U.S.C. Section 1014 on making a false statement for the purposes of influencing certain financial institutions and federal agencies include making statements that are misleading but not false? The case was decided on March 21, 2025. In Thompson v. United States, the Supreme Court unanimously ruled that 18 U.S.C. Section 1014, which criminalizes knowingly making any false statement to influence financial institutions, applies exclusively to statements that are factually untrue, not merely misleading. Chief Justice Roberts, writing for the court, emphasized that the statute's use of false indicates a focus on statements that are not true. The court highlighted that while some misleading statements may also be false, the statute does not encompass all misleading statements. Consequently, the court vacated Thompson's conviction and remanded the case for further proceedings. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Chief Justice Roberts delivered the opinion of the court. Patrick Thompson took out 3 loans totaling $219,000 from the same bank. Later, Thompson told the Federal Deposit Insurance Corporation, FDIC, that he had borrowed $110,000 from the bank. Thompson was indicted under 18 U.S.C. Section 1014 for making false statements to the FDIC. Thompson argued that his statements were not false because he had in fact taken out a loan for $110,000 just as he said. Both the District Court and the Seventh Circuit held that they did not need to consider that argument. In their view, the prohibition in Section 1014 against false statements extends to misleading ones as well, and Thompson's statements were at least misleading in failing to mention the additional loans. The question presented is whether Section 1014 criminalizes statements that are misleading but not false. Between 2011 and 2014, Patrick Thompson took out 3 loans from the Washington Federal Bank for savings. Thompson first borrowed $110,000 in 2011 to make an equity contribution to a law firm. Thompson then borrowed $20,000 from the bank in 2013 and another $89,000 in 2014, resulting in a total loan balance of $219,000. In 2017, the bank failed, and the FDIC became responsible for collecting the bank's outstanding loans. As part of that process, the FDIC's loan servicer, Planet Home Lending, sent Thompson an invoice in February 2018 listing a balance due of $269,120.58, which consisted of the $219,000 Thompson had borrowed plus interest. On February 23, 2018, Thompson called the customer service line of Planet Home Lending. During the call, which was recorded, Thompson told the customer service agent that he had no idea where the 269 number comes from. Thompson said, "I borrowed the money, I owe the money, but I borrowed, I think it was $110,000. Thompson agreed with the agent that he was claiming a discrepancy, and said that he was disputing the balance listed on the invoice. The agent told Thompson that Planet Home Lending would research the issue. On March 1, 2018, Thompson received a call from 2 FDIC contractors. The call was not recorded, but the contractors took notes. According to those notes, Thompson mentioned borrowing $110,000 for home improvement. Thompson and the FDIC ultimately agreed to settle Thompson's debt for $219,000, the principal amount of his loans. Thompson was later charged with 2 counts of violating 18 U.S.C. Section 1014. That statute prohibits knowingly making any false statement or report, for the purpose of influencing in any way the action of the Federal Deposit Insurance Corporation upon any loan. Count 1 of the indictment alleged that on the February 23 phone call, Thompson falsely stated he only owed $110,000 to the bank, and that any higher amount was incorrect, when he then knew he had received $219,000. Count 2 alleged that on the March 1 phone call, Thompson falsely stated that he only owed $110,000 to the bank, that any higher amount was incorrect, and that these funds were for home improvement, when he then knew he had received $219,000 from the bank and the $110,000 was paid to a law firm as his capital contribution. The jury found Thompson guilty on both counts. He moved for acquittal or a new trial, arguing that a conviction for false statements cannot be sustained where, as here, the alleged statements are literally true, even if misleading. Thompson argued that his statements about borrowing $110,000 were literally true because he had in fact borrowed that amount of money from the bank, even though he later borrowed more. The District Court denied Thompson's motion. It found that the Seventh Circuit does not require literal falsity in Section 1014 cases. The District Court acknowledged that Thompson's argument would have more traction in the Sixth Circuit, where a Section 1014 conviction cannot rest on material omissions or implied misrepresentations. But the district court concluded that Thompson had failed to direct the court to a Supreme Court case or Seventh Circuit case that holds that a Section 1014 conviction requires a literally false statement. The district court therefore found it unnecessary to address the government's argument that Thompson's statements were literally false, because literal falsity is not required to sustain a Section 1014 conviction. The Seventh Circuit affirmed. Like the district court, the Seventh Circuit concluded that it need not decide whether Thompson's statements were literally true because his argument runs headfirst into Seventh Circuit precedent. According to the panel, the Seventh Circuit had already decided in Freed that Section 1014 criminalizes misleading representations. The panel found that Thompson's statements were misleading because the implication of his statements was that he owed the bank no more than $110,000. The panel acknowledged the Sixth Circuit's contrary holding in Curlman, but it concluded that it was bound by Seventh Circuit precedent. We granted certiorari to determine whether Section 1014 criminalizes statements that are misleading but not false. We start with the text. Section 1014 criminalizes knowingly making any false statement or report. It does not use the word misleading. Yet false and misleading are two different things. A misleading statement can be true, and a true statement is obviously not false. So basic logic dictates that at least some misleading statements are not false. The government agrees with this principle, and even suggested an example at oral argument. If a tennis player says she won the championship when her opponent forfeited, her statement, even if true, might be misleading because it could lead people to think she had won a contested match. The government also agreed at oral argument with another example. If a doctor tells a patient, "I've done 100 of these surgeries," when 99 of those patients died, the statement, even if true, would be misleading because it might lead people to think those surgeries were successful. Given that some misleading statements are also true, it is significant that the statute uses only the word false. If that word means anything, it means not true, both today and in 1948 when the statute was enacted. Just as a matter of plain text, then, a statement that is misleading but true is by definition not a false statement. Adding any before false statement does not change that result. Certainly, any has an expansive meaning. But expansive, yes. Transformative, no. A statute that applies to any Ford owner does not cover all car owners, because the car must still be a Ford. So too a statute that applies to any false statement does not cover all misleading statements, because the statement must still be false. The government wisely agrees that false means not true. But, dictionary in hand, the government notes that false can also mean deceitful. And, thesaurus in the other hand, the government adds that false and misleading have long been considered synonyms. Absent from the government's account, however, is the fact that some misleading statements are not false, as the government acknowledged at oral argument. Given that fact, the government's textual arguments simply point out the substantial overlap between the two terms. That overlap is beside the point. Certainly, the statute's prohibition on false statements could reach some statements that are misleading, deceitful, deceptive, or mendacious, but only because those particular statements are also false. Regardless of whether other adjectives apply, the only relevant question according to the text of the statute is whether the statement is false. Statutory context confirms that Section 1014 does not cover all misleading statements. Again, the statute uses the word false. It does not use misleading. Many other statutes do, including other criminal statutes in Title 18 of the U.S. Code. Interpreting the word false to include misleading would make the inclusion of misleading in those statutes superfluous. Context from the time of enactment of Section 1014 further confirms that the statute does not reach all misleading statements. As we explained in a previous case, Congress originally enacted Section 1014 as part of its recodification of the Federal Criminal Code in 1948. 11 of the 13 provisions brought together by Section 1014 prohibited false statements, and none used the word misleading. These predecessor statutes were all enacted in the decades prior to 1948. Many other statutes enacted in the same period used the phrase false or misleading. The language of these other statutes shows that when Congress intended to cover all misleading statements, it knew how to do so. Precedent supports our reading of the text. For example, in a previous case, we held that Section 1014 does not incorporate a materiality requirement because the statute does not so much as mention materiality, whereas many other statutes do. The same logic suggests that Section 1014 does not reach all misleading statements. Our decision in another case is also instructive. The defendant in that case deposited several bad checks, then was convicted under Section 1014 on the theory that he falsely represented having more money than he had. We reversed the conviction because the defendant's course of conduct did not involve the making of a false statement for the simple reason that a check is not a factual assertion at all, and therefore cannot be characterized as true or false. That logic shows that a conviction under Section 1014 requires at least two things. 1. The defendant made a statement, and 2. that statement can be characterized as false and not true. The dissent in that case observed that this reasoning would apply equally to material omissions. Precisely so. If a material omission renders a statement misleading, Section 1014 still does not cover that statement unless it can be characterized as false and not true. A statement that is true but misleading does not fit the bill. The government contends that one of our precedents points in the opposite direction. In that case, this court described a predecessor statute to Section 1014 as securing protection against false and misleading representations, even though that statute used only the word false. Indeed, as the government points out, this court used the word misleading, or mislead, several times throughout the opinion. But nearly every time the word appears, it describes a person's intent while making a false statement, not the statement itself. And in describing the statute as securing protections against false and misleading representations, the court used the word and rather than or. That case thus did not suggest that misleading statements were independently unlawful under Section 1014's predecessor. Instead, the government's argument about that case again comes down to the overlap between false and misleading. Certainly, a statute that criminalizes false statements also criminalizes statements that are both false and misleading, or false statements made with intent to mislead. But the question before us is whether such a statute also criminalizes statements that are misleading but not false. The answer to that question must be no. The government argues that we should affirm on the alternative basis that Thompson's statements were false. But neither the District Court nor the Seventh Circuit answered that question, and we are a court of review, not a first view. Our holding shows, however, that this question is the right one to ask under Section 1014. And as the litigation before us has clarified, even Thompson agrees that context obviously matters in determining whether a statement is false. Thompson concedes, for example, that if he had made his statement in response to a question like "Did you borrow $269,000?" then his statement, in context, would have been false. We agree with the parties that at least some context is relevant to determining whether a statement is false under Section 1014. We leave for remand the question whether a reasonable jury could find that Thompson's statements in this case were false. In casual conversation, people use many overlapping words to describe shady statements: false, misleading, dishonest, deceptive, literally true, and more. Only one of those words appears in the statute. Section 1014 does not criminalize statements that are misleading but true. Under the statute, it is not enough that a statement is misleading. It must be false. The judgment of the Court of Appeals for the Seventh Circuit is vacated, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Justice Alito, concurring. I join the opinion of the court but write separately to summarize my understanding of the decision. 5 aspects of today's decision are most important. First, the court holds that 18 U.S.C. Section 1014 criminalizes only those statements that are false. Other related statutes refer to both false and misleading statements. But Section 1014 does not, so we assume the omission was intentional. The decision below, which held that Section 1014 applies to merely misleading representations, was therefore erroneous. Second, as used in Section 1014, the term false means not true. That is what it means in ordinary speech. Neither party advocates giving false statement a specialized or term of art reading, and the court rightly declines to do so. Accordingly, false statement in Section 1014 bears its ordinary meaning. Third, in considering whether a statement is false, judges and juries must view the statement in the context in which it is made. That is how people generally evaluate the truth or falsity of a statement. And since Section 1014 uses the adjective false in the ordinary sense of the term, the same approach applies. In ordinary speech, we do not regard a statement as true or false based solely on the literal or semantic meaning of its words viewed in isolation. 2 examples illustrate this principle. Start with an example adapted from the parties' briefs. After noticing that a plate of 12 fresh-baked cookies has only crumbs remaining, a mother asks her daughter, "Did you eat all the cookies?" If the child says "I ate 3" when she actually had all 12, her words would be literally true in isolation but false in context. The child did eat 3 cookies, then 9 more. In context, however, the child is implicitly saying that she ate only 3 cookies, and that is false. Consider another example, adapted from a law review article by Professor Richard Fallon. Parents James and Rachel are talking about their teenage son Alex. James enlists Alex to help rake leaves, but Alex is distracted and does little work. Afterwards, James tells Rachel, "As usual, Alex was a big help." Taken literally, his statement is false. But if James and Rachel have often spoken about Alex's unwillingness to help with household chores, Rachel would understand that James's statement was ironic and that James actually meant Alex was no help at all. So, in context, James's statement is actually true. Petitioner readily acknowledges that falsity must be judged in context. Courts should keep this important point in mind in future Section 1014 cases. Fourth, as used in ordinary speech, the terms false and misleading may overlap. A statement that might in ordinary speech be casually described as misleading may actually be misleading and false when viewed in context. Because there is no clear line demarcating statements that are false in context from those that are merely misleading, there is no reason why a court should make any reference to misleading statements in a Section 1014 case. It was error for the Court of Appeals to hold that Section 1014 applies to misleading statements, and it would likewise be wrong for a court to instruct a jury that it must acquit if it finds that a charged statement is misleading. The pattern jury instructions used in the various circuits avoid this problem, and our decision in this case does not necessitate any change. Finally, the question that the Seventh Circuit must address on remand is narrow. Although the Court of Appeals affirmed petitioner's conviction on the ground that his statements were misleading, the trial judge gave no such instruction to the jury. Petitioner did not object to the judge's Section 1014 instructions below, and he does not challenge them here. Instead of basing his request for reversal on instructional error, he moved after trial for a judgment of acquittal based on insufficient evidence. Thus, the applicable test on remand is whether, viewing the evidence in the light most favorable to the government, any rational finder of fact could conclude beyond a reasonable doubt that petitioner's statements were false in context. With these observations, I join the court's opinion. Justice Jackson, concurring. I agree with the court's conclusion that 18 U.S.C. Section 1014 criminalizes only false statements. I write separately to note that the pre-verdict instructions the district court provided to the jury in this case did not say otherwise. That is, while the lower courts may have misunderstood the scope of Section 1014, the jury was properly instructed that it could find Thompson guilty only if the prosecution proved beyond a reasonable doubt that Thompson made the charged false statements. For count 2, the jury specifically found that Thompson made all of the statements alleged. Moreover, and importantly, the jury was not advised that Section 1014 criminalizes misleading representations, as was mistakenly required by the Seventh Circuit precedent the court rejects today. Thus, in my view, there is little for the Seventh Circuit to do on remand but affirm the district court's judgment upholding the jury's guilty verdict. Whether Thompson's statements were, in fact, false is a question for the jury, and here, one the jury has already answered. At most then, the Seventh Circuit can properly assess whether any reasonable jury could have found that Thompson's statement satisfied Section 1014's falsity element. On this record, I think that legal issue is not subject to reasonable debate. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.